Greetings. This is Chapter 13, Disability Discrimination. And while the Title VII doesn't specifically cover disability at all, there are several other laws that we should be aware of that require us to make sure we accommodate those who have a documented disability. And we'll talk about the parameters within which that documentation has to occur. The laws that you're going to be focusing on are the ADAA, and the Vocational Rehab Act of 1973. So we'll get into all three of those laws, specifically how they handle what is considered to be disabled, what is considered to be an impairment or a perception of an impairment, and all sorts of things in this particular chapter. There are 11 learning objectives in this chapter. Number 1, we're going to understand the current environment for disabled workers in today's workplace. So obviously understanding the context as we have for all the other areas of disability, of discrimination. And our focus is going to be on understanding what challenges disabled workers have. We want to identify the challenges inherent in drafting, interpreting, and enforcing a disability anti-discrimination statute. It was not easy to come up with legislation to address this issue. It was really revolutionary at the time. I mean, we tried to some extent with the Voc Rehab Act in '73, but truly the ability to write the kind of legislation that we were able to was really groundbreaking in 1990. Of course, the challenges of that law have to do with the definitions, and that's constantly being litigated to figure out where the boundary conditions are for what is considered a disability, what is considered a function, a major life function, what is considered to be impaired, et cetera, what is reasonable in terms of an accommodation, what is undue hardship, as we've discussed with all the other areas, and the same thing holds here, and probably is even more challenging with the ADA. Number 3, outline a prima facie case for discrimination under ADA, ADAA, and the parallel Vocational Rehab Act of 1973. We're going to describe the term disability as it is defined by the ADA to be able to offer examples of covered disabilities or disabilities that may not be covered. So under what conditions is something considered a disability and under what conditions is it not? Explain how someone could be covered by the ADA when they are not at all disabled under the provisions for perceptions of impairment. So again, if someone is perceived to be disabled, they are still protected under the ADA under certain conditions. And we saw that with some other areas as well, right? I think with national origin, if I recall correctly, when we were talking about if someone perceives someone to be not from this country, and as those perceptions, they would still be protected under Title VII. Number 6, we will define major life activity and substantially limited according to the court decisions under the ADA. So what it means to have a major life activity, and what does it mean to be impaired in your ability to engage in that major life activity, and also what does it mean to be substantially limited in your ability to do something. Number 7, describe how employers can determine the reasonableness of any proposed accommodation. So there's some rules of thumb, and they're very similar to accommodations that we've discussed otherwise, where we want to consider the cost, the size of the company, and how pervasive the change would need to be in terms of the organization's infrastructure, what they can afford, all those things. We're going to outline the burden shifting framework of the ADA. Where does the burden fall? To make the case. We want to describe the defenses available to employers under the ADA. There are some defenses that an employer can make, and undue hardship is one of those. We want to describe how the law treats mental or intellectual disabilities under the ADA. They are considered disabilities, but there are some limits to how they are managed and handled in the workplace when it comes to the ADA. We're going to identify the distinctions between employer liability based on workers' comp and liability based on the ADA. Two separate issues, but they're related to each other, so we want to talk about how workers' comp and the ADA work together in concert, although they're not the same legislation. So there are two statutory bases for disability discrimination. Number one is the ADA of 1990, and it states no covered entity shall discriminate against a qualified individual with a disability because of the disability of such individual in regard to job application procedures, hiring, advancing, or discharge of employees, compensation, training, and other terms, conditions, and privileges of employment, which means we have to consider, disability and cannot be making hiring decisions based on the disability if they can do it with a reasonable accommodation. The Voc Rehab Act has similar language. No otherwise qualified individual with a disability in the U.S. shall solely by reason of his or her disability be excluded from participating in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance or under any program or activity conducted by any executive agency. So this was getting at, the Voc Rehab Act was getting at if you were working for the federal government as an executive agency, if you were receiving any kind of contracts or financial assistance from the federal government, you were required to follow the Vocational Rehab Act. The Americans with Disabilities Act in 1990 expanded that to most employers except under a certain level of size. There are a tremendous number of barriers for individuals with disabilities in the workplace. Some of it is physical barriers of not being able to get where they need to go or having not enough accommodations for their ability to just get from one place to another in the workplace, or things like that. And then there's also the attitude about people with disabilities. Often people are really uncomfortable about someone who has a disability, and instead of addressing their discomfort, they avoid it and they walk away from people, or they make presumptions that people are not capable of doing a job simply because they're sitting in a wheelchair. I will tell you that when I was at the University of Wisconsin-Madison getting my doctorate, there was a gentleman that ran the help desk. That was the central help desk. If you needed to know what building to go to, if you needed a map to go somewhere, he ran it, and he was legally blind. I mean, he had the dark sunglasses, he had a seeing eye dog. And that man could help anybody, anywhere, where they needed to go, how they needed to go. So I learned from that experience because of my own bias, right? But I learned from that experience that individuals with a disability absolutely can do any job if we're willing to make an accommodation, if we're willing to give them some help and support, and they can do this work. We also know that approximately 53 million Americans, 1 in 5 people, either have a physical or mental disability of some sort. And we'll talk about what some of those disabilities are in terms of the mental disabilities, particularly because we have more clarity with the ADAA about what is considered to be a mental disability and whether or not we have an obligation to accommodate someone given that. We do know from research that disabled workers, when properly placed in the right job, can equal or surpass performance of able-bodied workers. So there is no boundary condition unless there are physical limitations to what someone can do. And then we have to decide how much of that is essential and how much of it is not. And we cannot lump in any job task as considered essential because not all job tasks are essential. Employers should be disability blind and evaluate the applicant on their ability to do the job. Can they do the essential functions of the job with or without a reasonable accommodation? Period. Per Chapter 4, employers may directly inquire about COVID-19, at least in the middle of the pandemic. We certainly would not be asking them if they had COVID, but are they vaccinated or are they immune against it? And we can ask them to comply with screening for COVID to be able to work if we want people to be COVID-free in our workplace. The Vocational Rehab Act of 1973, the specific language is applied to the government and any firm that does business with the government, as I already said previously. Section 504 talks about federal employers and any program or activity receiving federal assistance. It doesn't really apply to private sector employment except for if you are receiving federal assistance. And Section 503 talks about it requires an affirmative action on the part of the federal government agencies to recruit, hire, and to train the disabled workers. And so, as we talked about affirmative action earlier in the term, what we're talking about is affirmatively and proactively going out to find workers who are able to do that particular work, who may be disabled for any particular reason. The Americans with Disabilities Act of ADA of 1992 extends the Rehab Act to protect employees in private sectors, and it has just a few modifications, but not many. It applies to all employers with at least 15 employees. It protects the protections extend to private sector and state and local government employees. Um, uh, the early success rate of disabled employees suing under the ADA was actually quite low, leading to Congress passing the amendment, the ADAAA, in 2008. So instead of the ADA being narrowly interpreted, the ADAAA mandated that it be more broadly interpreted, and it enabled different types of claims based on less severe or what one might consider to be a temporary disability. So it really tried to fine tune some of the language, and that's the challenge when you're trying to write legislation. It is an iterative process. We think we have it nailed and we think we have it clear, and then, as we start to see the courts interpreting things, it requires us to go back, and Congress, if they truly choose to protect individuals, to go back and protect, and make adaptations to better protect individuals who may be facing discrimination issues. Here are some of the realities about disability discrimination. It's highlighted in Exhibit 13.5 in the textbook. An employer may not question applicants about specific disabilities, only about their ability to engage in business-related activities and specific business-related activities. So, can you do the essential functions of the job? Number two, an employer may have to alter the working environment in order to accommodate a disabled applicant or employee, and this could mean some flexibility in working hours. It might mean a different type of desk. It might mean an amplifier on a telephone or a braille reader for people to be able to read documents. There's all sorts of things, and accommodations aren't necessarily overly expensive when it comes to an accommodation for someone to be able to do their job. Obviously, it is the structural accommodations of making buildings accommodating that are more problematic. Employees with disabilities have no more rights to their jobs than do non-disabled applicants. So it's not like people are given special rights or more rights, they just want to be given equal rights. If someone does not have a disability but others believe that they do, that person is protected against discrimination. So you could have, lose weight or something like that, and someone might look at you and think, oh, you're sick and you're dying, and so we can't have you here. That's not good for you. Or someone who may have had a heart attack 5 years ago, but they've been given a 100% clean bill of health. If you still treat them as if they are disabled, then they would be protected even if they're not. HIV status may be considered a disability under the ADA under certain circumstances. The definition of disability under the ADA is not limited to physical disabilities. It also includes mental disabilities and mental health issues, and we'll talk about some of those parameters. Employers are not required to provide any possible accommodation requested by employees with disabilities. It doesn't mean that any potential accommodation would definitely fly, right? It means that that there are some possible accommodations that the employee wants that the employer is just not able or willing to do, but they're willing to do different types of accommodations, and it has to be, again, a negotiated process. We'll try this, we'll see if this works, and we negotiate and navigate that. The need for a reasonable accommodation for a pre-employment test does not automatically disqualify an applicant from a job. So even if a pre-employment test requires, if somebody needs that reasonable accommodation to do that, still doesn't mean that they're going to be removed from the pool. And in fact, if they are removed from the pool because we had to give them a reasonable accommodation to take a pre-employment test, that would be considered a form of discrimination.